Sure.
Some of the president's remarks about the healthcare case in the Supreme Court have been interpreted as, challenging or putting pressure on the court ahead of the decision. Can you speak to that, and why not just allow the court to reach a decision and then
First of all, the president was asked a question and responded to it. Secondly, as I just said, he made an observation about why he believes that, well, first of all, that he believes the Affordable Care Act is constitutional, why he believes it's constitutional, and why he believes that the Supreme Court will, in keeping with 80-plus years of judicial precedent and Supreme Court precedent, will defer to Congress on its authority to pass legislation to regulate issues of national economic importance like our healthcare system. It's the reverse of intimidation. He's simply making an observation about precedent and the fact that he expects the court to adhere to that precedent. It's obviously, as he made clear yesterday, up to the court to make its determination, and we will wait and see what the court does. But I guess you could argue that circuit court judges who ruled on this were trying to intimidate or influence the court when they issued opinions, including very prominent conservative judges on the Court of Appeals, rather, when they issued an opinions that the Affordable Care Act was constitutional and that it is entirely constitutional in keeping with 80-plus years of judicial precedent.
On a different topic, the Pentagon said today that Khalid Sheikh Mohammed and
there you have it. Dipped in just at the right time, Chris. Some extraordinary comments there, suggesting that the argument really is that in 80-plus years of judicial precedent, the High Court has not struck down an attempt by Congress to regulate an economic matter. They're parsing words. I mean, let's just be frank with the viewers. They're parsing words because the Supreme Court in 1995 and 2000, as recently as 2000, has struck down a law passed by Congress pursuant to its powers under the Commerce Clause, which are exactly what's at issue in this case, saying that Congress overstepped its bounds. One was an attempt to regulate violence against women and allow civil claims for that. One was an attempt to regulate guns in a school zone. Both, Congress said, they affect commerce. We can regulate them. Both the Supreme Court said, you've gone too far. The Commerce Clause doesn't reach that far. So they're parsing words saying, well, it's an attempt to regulate a purely economic matter, this health care law. Let's just get that out there.
Well, absolutely. On that one, you say parsing, I say crawfish, and they're wriggling backwards on that and trying to make, to complicate and cloud the issue and say the president was shorthanding something else. That's one thing. But the other part here that is extraordinary, and you heard Jay Carney double down on and go further on, when the president made his initial criticism and he inveighed against what he called judicial activism, he compared himself to conservative commentators. There you heard Jay Carney comparing the president to circuit judges. Now, no offense to Charles Krauthammer, and no offense to any of the circuit judges in the country, but they're not the president of the United States. And the issue here and what that reporter was asking about and what we're talking about here that's so important is the separation of powers. The chief magistrate, the chief executive of the United States, respecting the process of the court and not interfering with it as they go forward. And what Carney's trying to do and what the president tried to do in his first remarks on Monday is set a lower bar for the president in terms of getting involved. Yeah, well, it's very interesting because it is a fact that conservatives believe judicial activism is the invention of law from the bench. They believe cases like Roe v. Wade are the invention of law from the bench, finding rights that they do not believe appear in the Constitution. The liberals believe judicial activism is striking down laws passed by a Congress. The president seemed to suggest that conservatives had taken the liberal view and that it would be inconsistent for them to then support the overturning of the health care law. It wasn't exactly apples to oranges. We'll talk about it with our legal panel coming up right here. Chris Direwalt, thank you. You bet.